Elizabeth, can you hear me?
I can
Elizabeth,
hear you. Can you hear me?
yes, perfectly. Just wanted to make sure you had a good connection.
Yeah, I can hear.
Thank you, Mr. Booth. Just wanted to make sure our court reporter was with us.
I'm gonna turn this down a little bit though. Good morning, councils.
Good morning.
Good morning, Your Honor.
Elizabeth,
Good morning, Your Honor.
good morning. Elizabeth Lusk, court reporter extraordinaire. Are you there?
Judge, we did a sound check a few minutes ago. She is there. She can hear.
Okay. This is cause number 4921, Elberta Film Royalty LLC versus Pioneer Natural Resources and Henry Resources. We are here on a motion for reconsideration, a motion for summary judgment, a motion for to lift discovery stay, motion for continuance. Councils, let me tell you what's going on with my court reporter. She is not able to join us by actual internet, and she's actually on a phone line. I have put us on YouTube. All right. So no poking of the nose or anything else that you don't want to come back and bite you later. So no, please know that you're on YouTube for what that's worth. Councils, let me start with having everybody identify yourself for the court reporter, and let's start with Mr. Booth.
All
Proceed.
right. Yes, sir. Richard Booth with Flint's Chapel and Alsop. And I'm here today and I'm ready. And I represent Pioneer Natural Resources USA Inc.
Mr. Berry.
Yes, Your Honor. Good morning. William Berry here on behalf of defendant Henry Resources LLC, and I have Trevor Chilton with me.
Okay. Okay. And then counsel that I will call Rob.
Yes, Your Honor. Rob Vardabedian, and I need to fix my name so that my whole name pops up there. Rob Vardabedian for Elberta, joined here by Nick Davis.
Okay. I see his, and you will be responding. Is that right, counsel?
Yes, Your Honor. Nick Davis may respond to some of it, but I will be responding to most of it, Your Honor.
All right. Let me go ahead and get started. Let's start with the motion for reconsideration. Counsel, Mr. Booth, one of the things that you put on your motion for reconsideration that I wanted to take up first is one of the things that you've alleged is that the point the mootness of the issue. And basically what you're saying is since the time that we met in Rankin for the MSJ, payment has been made. Am I correct on that, Mr. Booth?
Well, first off, the motion for reconsideration is Mr. Berry's.
Mr. Berry, thank you, counsel. Thank you, counsel. Mr. Berry.
Yes, Your Honor. Yes, my understanding is that Pioneer has fully paid all of the disputed royalty to Elberta. And
Okay.
yes, Your Honor.
So let me ask y'all this, counsel. Mr. Berry, the motion for reconsideration is yours.
It's my motion. Yes, Your Honor.
All right. And you represent Henry.
Yes, Your Honor.
All right. So counsel, since payment has been made, do we need to even revisit a reconsideration of the court's ruling?
Yes, we would like that, Your Honor, because Henry, our position is Henry is not a proper defendant in the case. And Henry did not pay any royalty to Elberta, but Elberta has sued Henry as a payor under the Texas Natural Resources Code. And that's the basis of our motion for summary judgment and our motion for reconsideration.
Okay. And so I've read your motion for reconsideration. The crux of your motion for reconsideration is Judge, we're not a payor. Am I correct?
Yes, Your Honor, that's correct.
And you rely on the case out of Eastland that says that being that you did not, open quotations, undertake those duties that you're not supposed, you can't be considered a payer, is that right?
Yes, Your Honor, under the plain language of the statute and under the case, the Devon case, which the facts are virtually identical to the case at issue, Henry is not the payor under the statute. Pioneer is. Pioneer has admitted that they are the payor. In response to our motion for summary judgment, Elberta said, we don't really care which one is, but our position is one of them needs to be the payor. Well, that is Henry, or that is Pioneer. Pioneer admits that. Elberta admits it. There, under the statute, there is the payor. There is no contract. There is no relationship whatsoever between Henry and Elberta.
Counsel, tell me, Gomez is a Hispanic name, Rob. Tell me what your name is nationality wise.
Vardabedian, and it's an Armenian last name.
Vardabedian, come again with Vardabedian.
Vardabedian, like Jared Tarkanian, Kim
Vardabedian.
Kardashian, lots of
Vardabedian.
Steve Sarkisian at UT, a lot of famous Armenians out there.
Vardabedian.
Anytime it ends in an IAN, Judge, it's almost always an Armenian last name.
That's interesting. And pronounce it for me one more time.
Vardabedian.
Vardabedian.
5 syllables. It's a rough one.
Yeah. Counsel, respond to Mr. Berry.
Yes, Your Honor. So first of all, we view the issue between Elberta and Henry as a close one, and it just comes down to which court of appeals you want to follow. Do you want to follow a case called Prize out of the San Antonio court, or do you want to follow this Devon case out of Eastland? The Prize case says that among the operator's obligations are the obligation to pay. That case has been cited 75 times. And then we have the Devon case relied upon by Henry, which is a case that has been far less popular with courts. It's only been cited once, and it was by a Delaware court. So we think you would go with the more established rule and put the obligation on the operator. And then where that takes us is we believe both Pioneer and Henry have obligations to us as payor. And we don't care who does it. We just want somebody to pay us and pay us in full. And that includes interest and attorney's fees. And we can talk about the issue with Pioneer later, but we view that as far less close.
Thank you, counsel. Mr. Berry, your client is Henry.
Correct.
All right. In my mind, counsels, I was thinking that Mr. Booth represented Henry, but Mr. Booth, you represent Pioneer.
I do.
Okay. All right. Now, the way that the story is told is, and the way that Henry, Mr. Berry, did not actually participate in the wells that are subject to this litigation. Is that right?
It's the other way around. Yeah, Your Honor,
Okay.
I can
I need
provide.
to drink some more coffee, counsels. Okay. Who drilled the well? Refresh my memory. I was reading this Sunday, but I was watching the LSU South Carolina game, and I had it straight then, and I've slept since then. Remind the court again, Mr. Berry, who drilled?
Okay, yes, Your Honor, I will. In 2020, that's when my client Henry began drilling the wells that are called the Pearl wells. There are 11 wells, and
Yes.
Pioneer holds oil and gas leases concerning those lands. And Pioneer did not participate in those wells. And so Henry and Pioneer were non-consenting co-tenants on the Pearl wells, or Pioneer was a non-consenting co-tenant with Henry. It is this is in our summary judgment motion. This is all undisputed. Henry provided all the payout statements, all the information to Pioneer that Henry was required to do under the law. Pioneer is the party who has a lease with Elberta, and the royalty is not an NPRI that goes with the land, which is the issue in the Prize case. That's why Prize doesn't apply. That was an NPRI. Here we have a lease royalty at issue. And so the contract is between Pioneer and Elberta. Henry is not a part of that contract. Henry does not have any privity whatsoever with Elberta. And the only claim that Elberta has brought against Henry is under Chapter 91 of the Texas Natural Resources Code, which requires that Henry must be the payor. And Your Honor, I have a few slides, if we can share the screen, that I can show you that might kind of help walk through this application.
Go ahead.
Okay. All right. So under Chapter 91 of the Texas Natural Resources Code, the payor is the party who undertakes to distribute. The party who undertakes to pay as the purchaser, as the operator, or as the lessee under a lease. So it is the party. That party here is Pioneer, because Henry, as is spelled out in the Devon court, which the citations to the prize court are not on the issue in this case. That's a long opinion, and there are lots of citations to other issues in that case, but not on this point. The Devon court looked at the prize court and said prize concerns an MPRI. Therefore, when you entered into the lease, the MPRI goes with the land you did undertake. Here, in our case, is exactly like Devon. Apache did not enter into a lease, and the court said, yes, then you did not undertake. Number two here, you did not undertake. And then in Chapter 91, we see here on the next one, that it specifically, when it's talking about the payment, it is what is specified in the lease or other written agreement between the parties. There is no lease or any written agreement in this case between Henry and Elberta. That is undisputed. And so Henry, as a matter of law, did not undertake to pay any lease royalty to Elberta. Henry had legal obligations to Pioneer as a non-consenting co-tenant, which Henry fulfilled those. Pioneer acknowledges that Henry fulfilled those. And so this whole issue here is between Elberta and between Pioneer on the lease. And like I said, Elberta has been paid in full. Now those two parties are arguing about interest and attorney's fees. That does not concern Henry. And that's why we filed our motion for summary judgment and our motion for reconsideration. And we're asking the court to grant our motion.
Respond, counsel. Vardabian, Mr. Vardabian.
Yes, Your Honor. So, and this, I'll be candid with the court about this. I've always thought that this issue with Henry is a closer issue, as I've said, and we've briefed it, and I do think, despite the fact that it's an NPRI, the prize case is instructive, and you would want to follow that case instead of a case that's hardly ever been cited before. The Devon case, I don't think the difference between it being an NPRI and a royalty interest in the lease makes any difference here. We just have one case that goes the other way from prize, in our opinion, that Devon case. And the court, in my view, can choose to follow Eastland or can choose to follow San Antonio. And we think that the better course is to follow the prize case in San Antonio.
And counsel, let me tell you, in my reading of the Eastland case, one of the things that caught my eye is that they said in that situation, which is kind of the situation that Henry, Mr. Berry is making, is in the statute, one of the key terms is undertake.
Yes, Your Honor.
And that they didn't undertake, to do this in this situation. Am I correct, Mr. Berry?
Yes, Your Honor, that is correct.
Okay, and let me ask y'all this, Mr. Berry. It's y'all are co-tenants. One drilled, but the other one didn't. And the one that didn't in this situation is Pioneer. Okay, in the big picture, Mr. Vardabian, Pioneer, your contract is with Pioneer, is that right?
Correct, Your Honor.
Okay,
And there's a little bit of I'll call it a loophole here, because we have the statute that says we need to be paid, Elberta, my client, needs to be paid within a certain period of time of the production being sold.
mhm.
And what ended up happening here is there's actually 2-year gap between when there was first production was sold, and then we eventually get paid right before a summary judgment hearing 2 years later. And so our view was either Henry needed to pay us, or Pioneer needed to reach out to Henry and work out something with Henry. Pioneer needed to pay us if Henry didn't pay them in time, and then Pioneer could have had potentially some sort of claim against Henry if Henry didn't pay them timely. But the issue here was our contract was with Pioneer. Pioneer initially made some inquiry with Henry, but then made no other effort to get us paid and never asserted claims against Henry or anything like that. And so the result was the statute says we get paid within 60 or 120 days, and instead it ends up being 2 years because there's this finger pointing back and forth at Henry and Pioneer. So that's really our issue. And had Pioneer done what it needed to do, there never would have been any sort of issue with Henry.
Okay, and I think that this is yes, Mr. Berry.
Yeah, that's just not true. There is no finger pointing back and forth between Henry and Pioneer. Henry and Pioneer have no dispute, no claims, no issues between themselves. He's trying to involve Henry in this dispute when they are not the payor and don't have a contract with them. There are no claims or contentions between Henry and Pioneer.
The part I care about, nobody was paying us, Your Honor. That's all I mean.
The way that I say it is Mr. Berry, that's what's the matter.
Right.
If you're the person that's not getting paid, I feel your pain, brother. All right. So councils, so in the big picture, now that everyone is here on as it were on the same page, literally, because we're on Zoom, this problem is not going to exist in the future as far as this relationship is concerned. Am I correct?
That's correct, Your Honor.
All right, because I know that I remember at the summary judgment hearing that this came about is we made I made the query, is this going to happen every single time that a payment is due?
And it won't, because Pioneer and Henry have now entered into a joint operating agreement that is for the future. Doesn't go back, it's for the future, and it's between Henry and Pioneer. And so that the issue of the non-consent has been resolved on Pioneer's.
Okay, and Mr. Booth, anything on this issue?
Well, yes, there is. And I'll say this. I was the attorney of record that handled the Devon Apache case. That was my case. They went up to Supreme Court and went up to the Court of Appeals.
In Eastland.
And it turned on a real simple issue, and that was this. You start out with the laws of co-tenancy, and you say that Apache was a co-tenant as the operator with the unleashed mineral owner, and Apache's rights it would be entitled to recover all of his expenses. But Devon had a lease. So the question is, does Apache have to pay the royalty on Devon's lease, which would affect Apache's rights as a co-tenant? It would lengthen its payout obligation. It would also give rise to fraud. And that is that if I'm an unleased co-tenant, somebody comes to me and wants to lease, I say, no, I don't want to lease, but I turn around and lease it to my brother-in-law at a 90% royalty. Then the operator's got to pay my brother-in-law a 90% royalty. So it was a deal that says you got to look at the relationships of the parties to start out with, and then look at what the statute says. And the court went off on that and said and it's talked about the fact that they were co-tenants, and then it says, no, Apache doesn't have to pay Devon's royalty. That's Devon's contract. And Devon's contract impacted Apache's rights as a co-tenant. And in this case, Pioneer stands in the shoes of Devon. Henry stands in the shoes of Apache. After after payout was reached on all the wells, because Henry accounted for all these payout on the project for all the wells. When the project paid out, Henry paid Pioneer, and within 30 days, Pioneer paid Elberta. So Elberta, and has been paid ever since. So
Okay.
the issue here is the only question, who's gonna have to pay attorney's fees?
Council, Mr. Booth, in the big picture, this thing, I think that it's not contended that, Pioneer and Henry are co-tenants. The plaintiffs justifiably said, okay, who owns this thing? These two people are the co-tenants. I'll invite both of them to the party.
Uh-huh.
I finally got paid, I finally have somebody's attention. From what it appears to the court right now is, I can see, Mr. Berry's point. In the big picture, I needed to go after who owns this thing. Mr. Berry and Mr. Booth's clients do. I bring them both to the table. When we have figured, and Mr. Henry, I do agree. That you're not the person that, or the company that undertook this. Now we know they need to direct towards Pioneer. I think at the end of the day, they expended some attorney fees. I think at some point attorney fees, because but for attorneys being hired on this thing, this thing went 2 years, I think that's what my ruling is. Mr. Berry's clients have been cleared. And now we're down to Pioneer. But before, or rather, I think now that the issue has been solved, now we figure out what attorney fees are.
Okay.
Thus,
Thank you, Your Honor.
thus, and so here is my question. All right, with what I have just told y'all, what do I still need to invite some people for the end of the month? I know that I know that discovery was stayed, but now it seems like the only issue at hand is going to be attorney fees. And counsels, tell me if I'm wrong, but to me, I think that with what I've just said, we're down to attorney fees. Do I need to have in panel or invite people?
Yes, no. So, Your Honor, if the ruling is summary judgment would be granted in favor of Henry, so Henry's out.
Yes.
In the summary judgment, we have cross motions. If the ruling of the court is, Pioneer needed to pay us per the statute, then the only question would be our attorney's fees. And Mr. Booth and I need to enter into some agreements, which we should be able to enter into. And then we would have a jury trial on attorney's fees. And we should be able to do that at the date set aside. And Mr. Booth and I should be able to reach those agreements today, I would think.
Here's what I need for y'all to do, counsels. All right. I know that this is spring break, and I know Mr. Vardabian, I have apologized in your absence, counsel, because I never liked, and I couldn't do beans about it. I never liked it when a judge set something for spring break when I had kids. And I apologize. And you haven't been in court. I've been in court all of last week, and I've used you I apologize to you and your family for having set this hearing on your spring break. And I'm hoping that that you're wearing a pair of shorts right now and you're somewhere where you're going to take this uniform off and go enjoy the day.
Your Honor, if it makes you feel better, I'm going to be skiing in a couple of hours, probably. So
Wow.
don't worry
Excellent.
too much about me. Everything will be
Excellent,
fine.
excellent.
With my
Ski
kiddos.
pants he's got on, not shorts, Your Honor.
That's right.
You
That's
know,
right. And
it-
my kids just learned to ski yesterday and they're very
Cool.
excited. And one of them is already better than I am after many
Good.
years. Getting
you
old
know,
is tough.
and us guys that have the graying hair will tell you, you know, there's many times that we missed opportunities. You know, you don't have your kids for long. You don't, you know, especially once that they go into high school, you know, you hi bye, and you go, you know, here and there and here and there. I hope that you enjoy the rest of it. Now, here's the reason that I had to do it here. The clerk has not yet sent out the summonses. All right, because I told her to hold off on this thing. You know, because I've got 3 towns. I've got Rankin, McCamey, and Midkiff. To the $1 million question to Mr. Booth and Mr. Vardabian is can y'all let me know fairly quickly if we still are going to have a jury trial on attorney fees, or is this something that can be bench tried? It doesn't matter to me, folks. You know, one of the charges that I take seriously as a judge is the constituents' time. All right, I'll sit in the courtroom forever and ever and ever. It doesn't matter to me. I've left the courtroom. I left the courtroom, Mr. Booth, one time at 5 o'clock in the morning.
Oh,
All right. Not recommended, you know, but you know, so counsels, let me know if y'all still need a jury. I don't have a problem with a jury trial. I don't. I just want to take careful consideration of people's time.
Your
Yes,
Honor,
Your-
may I make a comment?
Yes, counsel.
Okay, well, I do want to address one thing that Mr. Vardabidian stated, and he said that Pioneer had not paid according to the statute, which applies, which allows for attorney's fees for late and non-payment. The caveat to that is that the statute does not, and explicitly says it does not amend the terms of an oil and gas lease.
Mhm.
And this particular oil and gas lease says, and this is what our motions for summary judgment go back and forth, it says that the lessor reserves as a royalty unless he will pay 22% part of the net amount received by lessee for the sale of the oil at the time it is run into the storage tanks. Now, it is undisputed that Pioneer didn't sell any oil, period. It's also undisputed that Pioneer did not receive any of the net amount for the sale of production until November of 2022. So whether or not the statute applies depends first upon the construction of the royalty provision. Now, the royalty provision, we've argued, well, Elberta argues that royalty provision merely sets out a method of calculating how much royalty should be paid. We say it is, it says we don't have, yes, but we don't have to pay until the amount is received. Because it's undisputed, we didn't receive anything. And I really think that, and although it wasn't really argued, that both of our constructions are correct and they both apply. And what that means is that when the lessee receives the money for the sale, okay, it has to pay royalty calculated on the amount received at the time it's run into the storage tanks. But until Pioneer receives that money, it doesn't have to pay. Otherwise, you have to write out completely the words received by lessee. or received, excuse me, by lessee. If it simply said 22% of the net amount received for the sale of the oil, that would be one thing. And there are a whole lot of oil and gas leases out there. And I know where Mr. Vardabidian is coming from, because there's a lot of lease construction about proceeds and market value and proceeds received where, et cetera. And in every case that really turns on its own language, because there's not one size fits all anymore for these royalty calculations. And our position has been that until we receive the money, till the lessee, Pioneer, receives the money, it doesn't have to pay. But as soon as it receives the money, it is obligated under the terms of the statute to pay within 60 days or 30 days or whatever it is for oil and the same amount for gas. And you calculate the amount paid based upon the what it was received for the sale at the time it was run into the storage tanks. So that's where we disagree.
Okay,
If the court finds that we didn't have to pay until we received and gives effect to the received by lessee language, we don't need a jury trial. We don't need a trial at all, because they've been paid, and there's no question that Elberta was paid timely under the statute, based if it's calculated from the date Pioneer received those funds. If, on the other hand, the court finds that no, it didn't matter whether you got the money or not, you had to pay from date of first production, whether or not you sold the oil, whether or not you got the money, it doesn't matter. If you don't even know how much money was received, you still have to pay royalty from date of first production. Then we have a jury trial, I think, on attorney's fees.
Counsel, Mr. Vardabian, tell me again what you told me to that, respond, so you can refresh my memory the way.
Yes, Your Honor,
Thank you.
I will. I'll tell you what I said, and then I'll tell you what you said in our hearing too. So if Nick, could you share a PowerPoint? You can go ahead and skip all the way to, I think, slide number 8 or 9, because I think the parties agree that under the Natural Resources Code, that there would have had to been a payment within 60 days of sales unless the lease changed things, unless the lease changed it. And so let's just look at the lease. And Nick, are you able to share your screen?
Yes.
Okay.
Yeah, I know where you're going.
Yes, Your Honor.
And
And so
I-
and I'll just
and that's the same concern that I
as we're-
had back in Rankin.
as we're waiting on the language. So
Put
if
some
the
quarters in
sentence,
that thing, Mr. Davis, come on.
if it said when it's received, if it said when it's received, or if it said amount received, period, and then it didn't say anything else, and Mr. Booth was arguing, well, this means we don't have to pay until we get paid, and then Your Honor, the final question, final comment of the hearing in Rankin was, but that's not what the lease says, does it? It doesn't end there. It doesn't end with 22% part of the net amount received by lessee. If it had a period right there, or if it said when received by lessee, then Pioneer would be talking. But instead, it continues. If we go to the next slide, it says for oil at the time it is run from the storage tanks to the pipeline, which the well or wells is leaked. So that when oil, that's the time period when oil was run from the storage tanks, and there's no dispute that happened back when Henry was producing. That happened 2 years before we were paid. So that triggers the obligation. And then we'll tick through very quickly, Your Honor, there's a lot of cases about this that talk about at the well versus amount realized. And this Bluestone, I'm not going to read all these cases, but I just want to show you, this is something that gets litigated all the time. This language of how do you value the royalty? And the question is, do you bear post-production costs or not? And that's what this language is about. This language is about how you calculate and does the interest bear post-production costs? This isn't a get out of jail free card that says, Pioneer, you don't have to pay until you have the money in your pocket. And so that's what the lease says. The lease does not do anything to modify the arrangement between the parties. And so it was on Pioneer. Pioneer needed to reach out to Henry and figure out what amount of money needed to be paid to us. That didn't happen. Instead, there was 2 years in delay. And on top of that, there was this big fight about the meaning of the lease and all these other things that we had to litigate And so our attorney's fees ended up being a lot more than they would have been had, Pioneer just done what it was supposed to do in the first place, gone to Henry, get an accounting, get us paid timely. So that, Your Honor, is our position. And that's why I believe Your Honor at the end of the hearing said that's just not what the lease says.
And Mr. Booth, one more bite of the apple.
Yeah, well, here's the problem with what he's saying. It does say received by lessee. It does not just say proceeds. It just doesn't say received. It says by lessee. And every lease and all the Supreme Court has talked about words matter. But the other thing that what they're arguing is this. If they focus on the words at the time it is run from the storage tanks or into the pipeline.
Mhm.
Now, here's the problem. If you read that literally, there, as the court knows, there are a lot of wells out here that are low producing wells that run into the storage tanks every single day and every single month, but that oil is not sold until you have a full tank. So you could run oil into the storage tank every day for 3 or 4 months and then finally have a sale at the end of 4 months. What Mr. Bardabidian and what Elberta is arguing is that you have to pay within 30 days of the date it's run into the storage tanks, even if it's not sold at that time, or even if it's not picked up.
Mr. Booth, counsel, here's the concern of the court. The fastest way that I know for me to get reversed on the matter is for me to try to reinterpret a contract that is not vague. All right. That El Paso can reverse me without even needing to put a tie on. All right. This language is what it is.
Right.
And so I may, even if I agreed with you, Mr. Booth, the language is plain to a lay person. That language is plain of what it says. It says what it says. I can't change it. El Paso will reverse me if say, you know what, Mr. Booth, I mean, it is what it is, and that's what the language says.
Right.
So I think it's in the coulda, shoulda, wouldas, but it's not ambiguous. It's not vague. It's not for me to interpret.
Right.
The plain language is a plain language.
Okay.
Is it a great idea to have that language in there? I'll leave that to able counsel, but it's in there.
Okay.
All right.
All right. And so I do agree with Mr. Vardabidian about one thing. If the court's going to hold that Pioneer was obligated to pay from the date of first production, then we agree. They didn't get paid from the date of first production, on the date of first production. They didn't get paid sometime later. So the only issue then would be attorney's fees under the statute. We have not exchanged attorney's fees invoices. And at the last hearing, I made a proposal, and Mr. Vardabidian took me up on it, that said that we could exchange attorney's fees invoices and we could still be ready for trial on the 25th. I mean, all I got to do is get what his invoices are, what my invoices are. And what it's really going to boil down to is that they're going to get up and say, this amount in this time and this amount is fair and reasonable, or reasonable and necessary in Upton County, Texas. And we're going to say, no, it's not. Because we're pretty far apart on our respective attorney's fees that we've incurred in this case. So then the question is, should that be tried to the court or to the jury? Thus far, my client has wanted that to be a jury trial, to let a jury in Rankin County decide whether or not the rates and the time spent by Elberta's counsel is reasonable and necessary.
Yes, Your Honor.
I'd have to go back to get authority to do a bench trial, but I can say and I will do that and ask, and I'll let the court know. But as of right now, my counsel in-house counsel has told me a jury trial.
Mr. Booth, if we agree to exchange by Tuesday, would that give you enough time, or would we need to agree to exchange our billing information sooner?
Becky,
Oh, sure, sure.
Okay, we'll agree to.
We can dispense with reports. If you'd agree, I'll dispense with a report. You don't have to give me a report. I don't have to give you a report.
That's fine.
What we got to do is just say, this is what your invoices are. I'm going to say they're too high and you're going to say they're reasonable.
Yes, sir.
And so counsel, just so that I'm clear in my mind, Mr. Booth, are, at trial, are you going to also be asking for attorney fees, Mr. Booth?
Well, I can't now.
Okay,
Well,
so the only
no,
issue
I'm
now
not.
is,
No,
okay.
I'm not. And the reason is, the only reason I would be entitled to attorney's fees is under the declaratory judgment statute. And if the court's going to deny my motion for summary judgment, then I don't get a declaratory judgment in my favor.
Okay,
And besides all that, in 40 years, 50 years of practice, I've had somebody grant attorney's fees on a deck action maybe one time.
Doesn't happen too much, does it? I try a lot, but it doesn't seem to go anywhere.
Yeah.
Becky. I'm trying to get a hold of.
Yes, sir.
Becky, just so that council are gonna try to get this ready to try on the last week of March.
Okay.
Just to give them another date, do I have something available in April?
Let me go look. Hold on.
Okay. Just in case y'all don't can't do what y'all need to do by then, councils, let me see if I've got a date available that we could push it back a few weeks.
This case, I can assure you that if all we're doing is attorney's fees, I think we'll probably have only 2 witnesses. I'm sure on Mr. Varbidian, it'll be him or Nick or somebody. And for me, it will be me or Harper Estes.
Okay.
So we can do it in a half a day.
Okay. If we're looking realistically at just half a day, actually the whole last week of April is free. We don't have anything set that week.
Just keep that in mind, councils, so that if for some reason or another you need whatever time and still can't get to the March 25th. All right, keep in mind, my only urgency in this is I don't want to summon somebody and then have to back up and resummons them again in April.
Well, just be clear. Will if we do the trial that week, will it start on the 25th?
Yes, sir.
Okay.
Because I would imagine that we can pick a jury by about 2 o'clock, and it'll be a late day. But this is where my 5 o'clock in the morning comes in, Mr. Booth and Mr. Davis and Mr. Varbidian. I sent the jury in to deliberate on what I thought was a open and shut state jail felony at about 4 o'clock in the afternoon. And I ended up with a mistrial at 5 o'clock in the morning.
Oh, wow.
And human nature is very, very interesting. But council, just keep Becky informed as to if it does look like we're going to be able to do it on the 25th. Let her know so that we can go ahead and issue summonses. Counsel, Mr. Berry, if you will assist the court and send me an order pursuant to my ruling here today concerning your client, let me know. Mr. Varbidian, go enjoy. And I'm fixing to, I think my granddaughter plays at 4 softball in Midland.
Oh.
And so I'm going to go see a softball game.
All right, Sons, thank you. And I appreciate
y'all
you
take
setting up
care.
a Zoom.
Everybody, we're free to disconnect, Becky. Thank y'all, council.
Hey,
Thank you, Your
Rob,
Honor.
Thank
Thank
you,
you.
Your Honor.
Rob, can you give me a call?
Yes, I'll call you right now.